Greetings, everyone. So I'm going to go ahead and read some of the motion that was filed by Laura Guywin Baxter, and Valeska Paris against David Miscavige, Church of Scientology, International Inc., Religious Technology Center Incorporated, IAS Administrations Incorporated, Church of Scientology Flag Service Organization Incorporated, and Church of Scientology Flagship Service Organization Incorporated. And I'll try to link it. I don't know if I'll be able to. Case number 822 CV-986-T, P as in Paul, B as in Bravo, JSS. Order granting in part and denying in part plaintiff's motion to certify the court's March 31st, 2023 order for interlocutory appeal under 28 U.S.C. 1292B in clarification. This matter is before the courts on plaintiff's motion to certify the court's March 31st, 2023 order for interlocutory appeal under 28 U.S.C. 1292B and clarification filed on April 28, 2023, Doc 189. On May 12, 2023, defendants filed a combined response in opposition, Doc 190. Upon review of the motion response, court file and record, the court finds as follows. Plaintiffs are former members of the Church of Scientology. They were introduced to Scientology as children by their parents, and they remained active in Scientology as adults. As practicing Scientologists, they served for over a decade as members of the Sea Organization, Sea Org, which is described as a religious order within the larger Scientology religion. Plaintiffs bring this action pursuant to the Trafficking Victims Protection Reauthorization Act, TVPRA, 18 U.S.C. 1581-1597, alleging that defendants coerced persons, including plaintiffs, to join Sea Org and provide unpaid labor and services on a 328-ton cruise ship vessel known as the Freewinds, where defendants knowingly obtain valuable benefits, including financial enrichment. Plaintiffs allege that Freewinds frequently sailed to nations where anti-trafficking measures were weak to avoid legal repercussions, and it has never docked at any port in the United States or even entered the territorial waters of the United States. Plaintiffs allege they were forced by their parents to join the Church of Scientology as children, where they were indoctrinated, manipulated, and pressured into coercive circumstances from a young age. Doc 79 at 3. They now contend that Scientology was a world filled with abuse, violence, intimidation, and fear. It et al. 1. For a time, plaintiffs were assigned to work on Freewinds under highly dangerous and abusive conditions, often working between 16 to 24 hours a day. In the amended complaint, plaintiffs detail numerous incidents of punishment, humiliation, interrogation, and imprisonment that occurred while they were members of Sea Org, including various acts of mental, physical, and emotional abuse. I can't help but think, who were the people on the Fairwinds? Inquiring minds want to know, don't they? As members of Scientology, plaintiffs signed pledges of eternal service to the religion and its goals. In enrollment agreements signed in 2003 and 2004, plaintiffs agreed to resolve disputes with the church through binding religious arbitration. Plaintiffs were between the ages of roughly 19 and 25, relatively young adults, when these arbitration agreements were signed. Guywen Baxter was born April 9, 1982. Laura Baxter was born October 25, 1984. And Valeska Paris was born in 1978. Who was on the free winds back in those days? Plaintiffs later left free winds and they executed agreements to arbitrate them as well. Paris in 2007 and the Baxters in 2012. Paris, when she was roughly 31 years of age, signed another agreement and release in 2009 that included an arbitration provision. Similarly, the Baxters signed additional agreements which included arbitration provisions in December 2015 when they were roughly 33 and 31 years of age, respectively. On March 31, 2023, the court entered an order compelling arbitration and staying the case pending arbitration. Plaintiffs now request that the court certify its decision compelling arbitration for interlocutory appeal and seek clarification. Defendants oppose the motion. Legal standard. Interlocutory appeals under 28 U.S.C. 1292b are designed specifically to resolve abstract legal issues or issues of pure law. PFM Air Incorporated versus Dr. Ing. H.C. F. Porch, A.G., 751 F. Supposition 2D 1264-1269, MD, Florida, 2012. Internal quotations omitted. When a district judge, in making a civil action an order not otherwise appealable under this section, shall be of the opinion that such order involves 1. A controlling question of law, 2. As to which there is substantial ground for difference of opinion, and 3. That an immediate appeal from the order may materially advance the ultimate termination of the litigation. He shall so state in writing in such order, 28 U.S.C. 1292b. The party seeking the appeal bears the burden to establish that it has met all three elements. Guernsey v. Penn Credit Corp., 619 CV 823, June 18, 2020. Analysis. Plaintiffs request that the court certify 2 questions for interlocutory review under 28 U.S.C. 1292b. 1. Whether plaintiffs' fraud in the execution and duress challenges to the arbitration agreements must be heard by a Scientology arbitrator rather than the district court, and 2. Whether forcing plaintiffs to participate in Scientology religious arbitration violates their First Amendment right to leave their religion, violates their First Amendment right to leave their religion, violates their First Amendment right to leave their religion. Upon review, the court finds that the issue presented by plaintiffs satisfy the standard under 1292b. After considering the parties' positions, the court finds that the 2 issues involve controlling questions of pure law, which the appellate court can decide quickly and cleanly without having to study the record. See McFarland v. Concesco serves. 11th Circuit Court, 2004. Although the questions are not controlling in the sense that reversal of the March 31, 2023 order would terminate the action, considering the system-wide costs and benefits of allowing the appeal, the court believes that clear guidance from the 11th Circuit will aid district courts in a large number of cases. See Islam v. Lyft, Incorporated, 2021. SDNY, June 28, 2021. The court also finds that there is substantial ground for difference of opinion as to these issues. The court emphasizes that it did not come to its decision to compel arbitration lightly or easily, and the controlling legal issues present difficult questions that have not been squarely addressed by the 11th Circuit or United States Supreme Court. There is certainly room for disagreement, even if the court ultimately found defendants to have the stronger positions. Finally, the court finds the interlocutory appeal may materially advance the ultimate termination of the litigation. 28 U.S.C. If the 11th Court hears the appeal and affirms, this case will remain stayed pending resolution of the arbitration proceedings. If the 11th Circuit reverses holding that plaintiffs cannot be compelled to arbitrate, it will save the parties the expense and burden of arbitration, which may potentially take years, and allow the case to proceed to resolution in the district court. In addition, considering the system-wide costs and benefits of allowing the appeal, including the impact that the appeal will have on other cases, an interlocutory appeal may not only resolve this case but also conserve judicial resources in the longer term by resolving important and oft-arising legal questions. See Islam 2021, WL 2651653 at 5. Internal quotations and citations omitted. Based on the foregoing, the court concludes that each of the 129(2)b requirements for an interlocutory appeal are met. Therefore, on its discretion, the court chooses to certify the March 31st, 2023 order to allow the interlocutory appeal of the discussed controlling questions of law. 1. Whether plaintiffs' fraud in the execution and duress challenges to the arbitration agreements must be heard by Scientology arbitrator rather than the district court, and 2. Whether forcing plaintiffs to participate in a Scientology religious arbitration violates their First Amendment rights to leave their religion. If the 11th Circuit agrees to hear this appeal, however, it may address any issues fairly included with the certified order. See Yolanda Motor Corps, USA versus Calhoun, 516 U.S. 199, 205, 1996. The court declines to clarify which arbitration provisions govern or identify which terms control the parties' agreement by resolving any alleged inconsistencies between the agreements. The March 31st, 2023 order speaks for itself on this and other issues. According, it is hereby ordered, adjudged, and decreed. 1. Plaintiff's motion to certify the court's March 31st, 2023 order for interlocutory appeal under 28 U.S.C. 1292b and clarification, Doc 189, is granted in part and denied in part. 2. The motion is granted to the extent that the court's March 31st, 2023 order is certified for an interlocutory appeal pursuant to 28 U.S.C. 1292b. 3. The motion is otherwise denied. Done and ordered in chambers in Tampa, Florida, this 7th day of June 2023. Tom Barber, United States District Judge. So that's it for the motion to certify the courts given by Laura Guywane Baxter. Guywane Baxter, Laura Baxter, and Valeska Paris. Case number 822 CV-986-TPB, sorry guys, -JSS. Have a good day, good night, wherever you are. I will try to put the link in the description if I can. Peace.